Okay, we start recording now. All right, here's the offer as it was written and sent to the listing agent. Everybody, I told you all to put an offer date of sometime in February. Mine happened to be the 26th. I have the property address, the MLS number, and the tax ID number. Did anybody get the tax ID number and get it into their offer? That tax ID number was in the listing, and it was also on the legal description. So then I attached the legal description that was pulled from GSCCCA. Or if you noticed, I don't know, did anybody notice? There was a legal description attached to the listing. When you guys pulled the listing, did any of you notice that there were documents attached? Or do you know how to do that? Okay, let's go to FMLS. Okay, we're going to log into FMLS. And we're going to go to Matrix. And we're going to pull this listing. Okay, so if you look at this listing, it has in here the tax ID. See the tax ID right here? I'm hearing lots of head rattling. And then up here at the top, there's a little icon that looks like it's a couple of pages. Those are documents. A listing agent can attach disclosures and other documents to the listing. And if you click on that, that's where you'll find the legal description, the association disclosure, and the seller's disclosure. You can pull those documents down and you can use them when you're making your offer. So instead of calling the agent and say, can you send me the disclosures? If you've got that little icon there, you can pull them down yourself automatically. So we are going to go back to our offer. I am. Okay, so the legal description I attached from the listing. And after we're done going through this, I'll show you how to pull it from GSCCCA. But the purchase price to be paid by the buyer is $350,000. Seller's contribution at closing to be $11,375. Closing date on or before March 27th, with possession at closing. Holder of the earnest money is Keller Williams Realty Metro Atlanta. The closing attorney we requested was Partnership Title, the law office of Kirsten Howard. We said we were going to provide earnest money in the form of a check in the amount of $1,000 within 3 days of binding agreement. We requested 10 days of due diligence. The house was not built prior to 1978. I am representing the buyer as a client. The listing agent with Keller Williams Realty Atlanta Partners is representing the seller as a client. Again, if a listing is in the multiple listing service, you can bet that that agent is representing that person as a client because they have to have a listing agreement or a contract to be able to put that property in the MLS. So sellers are always clients. Again, except with Rhonda Duffy. And the time limit of the offer was 5 p.m. February 28th, the next day. Now, who didn't fill out their offer like that? There shouldn't have been any issues, but I want to know if there were. So everybody did okay with that? Okay, so on page 7, oops. The exhibits attached to this offer are going to be a community association disclosure, a conventional loan contingency exhibit, the legal description of the property, the seller's property disclosure, and the lender pre-approval letter. Now, did everybody pick those items and give them a letter designation? I've picked C, D, A, B. Doesn't have to be in any particular order, just happens to be the order that I chose. So you see how I did that? Now, the hard part was you needed to write 3 special steps. You needed to write a special step about a home warranty, a termite letter, and warranties to be transferred at closing, particularly for the new roof that had gone on the house. So the steps that I wrote, short and sweet: seller to provide a home warranty from Old Republic Home Warranty at a cost not to exceed $600, good for 1 year from date of closing, to be ordered by the selling agent. Who, what, when, where, why, basically answering all the questions. Who? Seller. To provide what? A home warranty at a cost not to exceed $600. When? Good for 1 year from the date of closing, to be ordered by the selling agent. Okay. Seller to provide a clear termite letter 7 days prior to closing. This seller, if anybody pulled the seller's disclosure, does not have a termite bond. So because my buyer was being was firm on their offer, let's put it that way, and I thought it was an awfully low offer, I didn't want to ask for a termite bond, and I didn't suggest they ask for that. I said, let's just ask for a letter. If there's no termites, then you're good to go, and you can get a bond from a company that you want to have your bond with versus allowing the seller to pick that. And that's how I worded it. If there were termites, the seller was going to have to get a bond to get a clear termite letter. At that point, my buyer wasn't going to have a lot to say about who was going to be able to do it. My buyer was also concerned about the warranty on the roof because the roof was only a couple of years old. So I said, seller to transfer all warranties to include but not limited to the roof and all mechanical systems in the home. Mechanical systems are the water heater, the air conditioning compressors, the HVAC units, those sort of things. So does that help clear things up if you had any questions about how to word some steps? Or was everybody able to pull the stipulation wording that FMLS or that is provided in FMLS RDocs? Okay. And then, of course, on the signature page, and I've got everything blacked out here, but the system automatically populated for me the listing agent's information, except her realtor membership. It automatically populated all my information from my profile. So the next thing is the legal description. And the legal description, as you can see, and as I alluded to yesterday, is automatically labeled Exhibit A in a lot of instances in GSCCCA. So, but this is what's called the long legal for the property. It talks about the land lot, the district, the lot, the block, yada, yada. You can't get a better description of a property other than this type of long legal with a plat book and page and a deed book and page where it's currently recorded. And you always want to use that when you're making an offer on a property. Especially since we have free access in the office, there's no reason not to. Okay, Exhibit B was the seller's disclosure that was provided attached to the listing. Typically, that is provided with the address already filled out. So you need to give it a letter a number or a letter designation, and you need to put in the date of the offer that you are making. And down below is all the information on the property to the best of the seller's knowledge, okay? It says here that there's nothing structural. They don't know how old the systems are. It's not unusual for a seller to check a lot of these in this manner. They say it's public water. They don't say if it's sewer or septic, so I had to call the county to get that answer for my buyers. They did say the roof is about 3 years old. That's why we asked for the roof warranty. They said nothing about flooding or soil or boundary issues. And then they indicate here there is not a termite bond. That's why we asked for the termite letter. Those are the things that you look for. It also talks here, sorry, I skipped past this, whoops. Environmental issues, are there any buried tanks? Have there been any mold, lead, or radon testing? Has there been any litigation or insurance issues? Well, this owner has made 2 insurance claims. See here? The roof was replaced with one of the claims, and the hardwood floors were replaced with a second claim because the refrigerator leaked on the main floor. There are no other hidden defects according to this seller, no other additional explanations. And this page provides a detail of what they're leaving when they vacate the property and turn it over to the buyer. They're leaving a dishwasher, the garage door opener, the garbage disposal, microwave oven, wall oven. They don't have a stove. They had a surface unit cooktop. Now, sellers often check the wrong boxes here. So as a listing agent, you need to check these things. They had a wine cooler. They are not leaving any refrigerators. There were, I think, 3 refrigerators in this house. They took them all. Very unusual, but they took them all. They had huge flat screen TVs mounted on the wall and did not indicate they were leaving the TV mounts in brackets, which meant that they were going to remove those and they would have to repair the wall before closing. There were speakers and speaker wiring that was built in. So of course they were leaving that on and on and on. On the seller's disclosure, you also have the ability, or the seller has the ability, to provide clarification regarding multiple items. If they check they're leaving a refrigerator and there's 3 refrigerators in the property, they would say, I'm leaving the refrigerator in the garage, or I'm leaving the refrigerator in the kitchen and taking the remaining refrigerators with me. Items in need of repair, if they're leaving a refrigerator that has a broken ice maker, or the refrigerator has a broken freezer, or it just flat doesn't work, they would indicate here that the refrigerator in the garage has a non-functional freezer and they're not going to fix it. So when you go through with your home inspector and do your home inspection, don't ask them to fix that, because if they've indicated on here that it's broken and they're not going to fix it, they're not going to fix it. Then we got an association disclosure that, again, I gave a letter designation to and filled out the date on. It is a mandatory membership association, but it is not age restricted. It is not a 55 and older community. There is not a master association. This is an older form, by the way, because this house was listed before 2020. This is the association mailing address where the association dues are paid or mailed to. They indicate that there are no fees to transfer the membership. So if there were, the seller was going to have to pay those on behalf of my buyer. They say here that the annual dues are $545 paid in 2 installments. That there are no utilities or services that are included for that, but there is a pool, tennis courts, clubhouse, playground. There is also a lake. There is no room here for lake. They should have checked this box and said lake. It also includes common area insurance for the clubhouse and other areas, which they did not check on here either. So they should have checked that. And there are no special assessments, no litigation. Seller has not received any notices of such. And then everybody initials that. Now, the conventional loan contingency. This is, I gave a letter designation to it, date of the offer, property address. My buyer was getting a first mortgage for only 25% of the purchase price, roughly. Did everybody who worked on that, did you get that approximate number? She's putting $250,000 down on a $350,000 purchase. So she's financing $100,000. That is approximately 25% of the purchase price. The term was going to be a 30-year mortgage at a 3.5% interest rate that would be fixed from an institutional lender. And I gave you a loan approval letter from Navy Federal Credit Union. Now, she indicated she might also use USAA, but she had a pre-approval from Navy Federal and wanted me to submit that with her offer. Now, Navy Federal is really difficult to work with. I have firsthand knowledge of that because they are my bank. They are very slow to approve mortgages. Closing dates are just a suggestion. So I requested on a 30-day close 28 days for loan approval because I know what Navy Federal does. I expected pushback on that number, but I requested 28 days for loan approval, as I indicated on the worksheet that I gave you. I also requested 21 days for the appraisal because, again, Navy Federal is notoriously slow. So now everybody signs this exhibit. Here's the pre-approval letter from Navy Federal indicating a purchase price of $350,000 with a loan amount of $100,000. And then I also included the instructions to closing attorney that indicated that the seller was paying a 6% commission and 3% of that would be given to Keller Williams Realty Metro Atlanta. That the buyer was not paying any commission. When you have a buyer brokerage, if the seller isn't paying you a full 3% commission and you indicate it on your buyer brokerage, your buyer could be paying your broker commission to make up the difference between what you're receiving and the full 3%. There were no referral fees being paid, no special steps on this, and I signed it. And this was the offer, the full offer that I sent over to the listing agent. Any questions? Okay. All right. Ryan is asking a question. He's in the room with me, so if you can't hear him, I'll let you know what his question is as soon as he finishes. You sure? Okay, he changed his mind. All right, Naruna, if you will send me an email. And remind me to send you the documents, the GAR forms, so you can do this exercise as soon as the conference call is over. I'll send them to you. Okay, so from there, we did eventually get a counteroffer on this. Actually got a counteroffer fairly quickly. Next week on Monday, on the call, we're going to cover counteroffers. But today, we're going to go ahead and we're going to move into the other GAR forms that are standard exhibits to a contract. And we're going to start with the other finance contingencies. So we're going to go to the FHA finance contingency. It is just like the conventional finance contingency in the beginning. You give it an exhibit letter, offer date of with the property address. And it talks about a first and second mortgage loan. Typically with FHA, the buyer is getting a loan that is 96.5% of the purchase price. That is the most that FHA will lend. Sometimes people are put down a 5% down payment, but typically they're only going to put down 3.5% because they want to save either as much money as they have in their bank account as they can, or they only have 3.5% to put down. You are going to again indicate an approved mortgage lender. And you're also going to indicate a number of days for financing approval, typically somewhere 21 to 28 days. The difference becomes on page 2. There is no appraisal contingency deadline. The appraisal is included with the financing. So they run together side by side in parallel, and the appraisal has to be back and approved at the same time the loan is approved. So you only have one date time frame that you have to put in an FHA contingency. Does that make sense? Now, what you do have in an FHA contingency is a number that the property has to appraise for. So if you're purchasing a property and you're offering $100,000 on it, it has to appraise for $100,000, or the seller is going to have to reduce the purchase price, or and if they don't, FHA will deny the loan. That is not always the case with conventional, but that is the case with FHA. So you put in either the amount that you're offering on the property, or you can put in the words purchase price if you expect you're going to get a counteroffer because you're offering too low. So that's entirely up to you, but again, these days, most of the time we are offering the full purchase price of the property, and putting a number in here is, I prefer putting a number in there. Let's put it that way. Mortgage insurance premium. Now, FHA has MI, mortgage insurance, because you are borrowing more than 80% of the value of the home. The FHA upfront mortgage insurance premium is 1.75% currently. It's the same for everybody. No, that number is 1.75. Marquise, wake up. So that's not a number that changes very often, but that number does change on occasion. But right now it's 1.75%. The buyer has the option to pay that amount in full at the closing table as part of their closing costs, or they can add it to the loan amount and finance it in. Most people finance it in, but if you've got a seller that's willing to pay a lot of closing costs, because with FHA, they will allow a seller to pay up to 7% of the purchase price in closing costs. And if you've got a seller that's willing to do that, and there's enough room in there for that to be paid up front, it can be paid up front. So even if it's added to the loan, you're still paying a monthly mortgage insurance premium. The mortgage insurance is expensive. It's just expensive. And these days, it's not automatically removed at a certain point, but the property, once it has a loan to value of at least 80% on the amount that is still owed, a buyer or the person who has the mortgage can go to their mortgage company and request that they do an evaluation of the purchase price, or they can have an appraisal done to get that mortgage insurance removed. Mortgage insurance is somewhere around $75 or more a month. And getting that taken off your payment on an annual basis is well worth paying $350 or $400 for an appraisal. Okay, in addition to the fees that the seller agrees to pay for closing costs, there are tax service fees. They can be paid as part of what is already being paid by the seller, or you can ask that the seller pay those in addition to. There's not a lot. It is up to you and your buyer which box you check. So on the next page, repairs required for an FHA commitment letter. FHA appraisers are the same appraisers that appraise property for conventional loans or anything else. But they have specific requirements when they're doing that appraisal to check for certain things. FHA requires that there's no broken windows, no broken glass, that all installed appliances are in place. Installed appliances are stoves, dishwashers, and vent hoods. That vent hood doesn't have to be a microwave, but there can't be a hole in wires hanging there. The same with the stove and the dishwasher. There has to be an HVAC system that is functioning, that provides hot air and cold air. Hot water has to come out of the hot water tap, cold water out of the cold water tap. There has to be floor coverings on all of the floors and all of the living spaces. If you've got a basement and it looks like they've ripped up the carpeting, but it's not finished to the point where it would be standard living space, you're okay. But if the carpet is missing in the living room, FHA is going to require that carpet be installed before closing. They also want to make sure that all the other fixtures are in place. So light fixtures, there have to be light fixtures. There can't be a hole in the ceiling with wires hanging out. There has to be a light fixture installed there. So appraisers have a list of things that they check when they go into a house to do an FHA appraisal, and they can red flag those items in the appraisal. FHA won't provide a commitment letter to lend on the property unless those things are all in place. Rotten wood's another one that they hate. Leaking roofs and rotten wood. So if any of those items are flagged, they will come back from the lender for your buyer as a condition to lend. And all those conditions have to be cleared, and the appraiser has to go out and verify them before closing can occur. You have to put an amount in here as to if you think any repairs are needed, what is the most that the seller has to pay before an issue is made of it. So you can put that the seller is going to pay up to $500. If it goes over $500, they can still pay it. It can still be negotiated and it can still happen. But up to $500, they can't complain, basically is what that means. If it's $1,000, it's $1,000. It's whatever you put in here, but don't get crazy and put something like $5,000 because it's going to get changed. The seller's not going to accept it. Their agent's not going to let them. Now, when you have a seller who is selling a distressed property as is and cannot make any repairs, it might be your buyer that has to do those repairs. And if your buyer cannot afford to do more than $200 in repairs, $200 is the limit. And then if the repairs come back, the request for repairs comes back and it's in excess of $200, the contract will be terminated and everybody will go to their corners. Does that all make sense?
Yeah.
Okay. The seller may also be required to pay for certain lender required inspections like septic tanks, wells, and termites. All right, the buyer doesn't have to pay for those. Home warranty, if the improvements on the property are less than a year old, seller shall, if required by FHA, provide a home warranty. That's required by FHA. I haven't seen FHA ever do that, but I'd be interested to see a situation like that. Let's put it that way. May be obligated to connect to public sewer. If sewer runs through the front of the property and is easily accessible to the property and can be easily connected, and the property is still on a septic tank, FHA might require that seller pay for that connection to the sewer system. I've had that come up before. So what you've got to do is you've got to figure out who agrees to pay what here. Connecting to the sewer system can cost $5,000 to $10,000. I see a lot of agents that don't know what they're doing, and they'll say that the seller, whoops, will pay for the cost of the connection not to exceed $1,000. That's crazy. It's going to cost more than that. If that's the case, look at the listing, look at the disclosure, figure out if the property is on septic. And if it's on septic, is that the general conformity of the neighborhood, or do you think maybe that neighborhood is on sewer? Most properties, this hurdle's been cleared, but I listed one 2 years ago. Everybody on the street was on sewer except my house was on a septic. Well, my house was at a turn in the road where the road made a sharp 90-degree turn. The sewer line was on the other side of the road. It was not feasible to break open the road, to bring a sewer pipe across the road to hook this house to sewer. And that's why it was not connected. So we were able to not have to do anything about that, but we had to get something from the county that attested to the fact that it just was not feasible to connect this house to sewer. There's also a certification of an arm's length transaction. FHA prefers arm's length transactions. That means there is no relationship between the buyer and the seller, business, blood, or otherwise. So most of the time you're going to check this is an arm's length transaction. If it is not, and the buyer is buying their home from mom and dad, or they're buying their home from their aunt and uncle, you have to disclose that, and FHA has to approve it. Just know that. And then we've got the signature section. So any questions about an FHA loan contingency?
You mentioned that there's a maximum that the seller can help pay. Was it 7,000?
No, I mean, it's whatever you put in there.
Okay, all right,
The maximum is what you put in there.
gotcha.
But if you walk into a house and you know the deck is rotting and falling off the back of the house and you're afraid that FHA is going to call it, put in enough money there to cover putting in a new deck.
Okay.
But if you don't, again, it can still be negotiated as part of the contract, but the seller, if it is in excess of any amount that's in that box, can say, no, I'm not going to pay it, or I'm only going to pay $1,000 for the deck replacement. Your buyer can pay the rest. Okay.
Okay.
Maybe it was
That makes
closing
sense.
costs. Were you saying there was a limit on what the FHA allows sellers to contribute towards closing costs or something?
7% of the purchase price.
7%.
That's
Yeah.
what it was.
Yeah.
When you request seller paid closing costs in the purchase and sale agreement on page 1, you can ask for up to 7%. I've never seen a seller pay it. Never seen a seller pay more than 3%. But the lending limits for FHA will allow up to 7%.
Of the sales price.
Correct.
Okay.
None of that money can go toward down payment. It's only closing costs. Closing costs are escrows, loan origination fees, other, appraisal fees, other lending fees, but 7% is the maximum allowed by FHA. Okay? So we're going to go to the VA finance contingency. Again, very familiar first page. We know how to fill that out. VA loans are typically 100% financing. That is a privilege that's allowed to veterans for serving this country. And There's only one other loan program that allows 100%, and that's USDA, and it has a rural development requirement to it. You're not going to see it very much. So just know that mostly VA loans are going to be 100% financing. Oh, Brian just said as of March 12th, its FHA max is 6% seller pay closing costs, so they changed it. Wasn't aware, thank you. So it's not 7%, it's 6. Brian, is VA still 7? VA has typically been 7 in the past also. So, but the VA loan contingency, again,
I don't think there's any changes to VA. It's FHA. I'll double check though.
okay. Brian was a loan officer, for those of you who don't know that. So he's tied into that more than I am. But again, a very familiar first page. Everything is the same as every other finance contingency, including the number of days that the buyer has to get approval for their financing. VA financing tends to take 45 days. Sometimes it can be achieved in 30 if you've got a really good loan officer who knows how to work the VA system. But the VA has their own appraisers, and they are veterans, and they're assholes. I'm a veteran. I have used my VA. My appraiser was an asshole. But they feel like it's their job to protect the veteran by doing that. They were probably the same type of person when they were on active duty. So anyway, VA appraisals take a long time. VA appraisers will go through that house with a fine-tooth comb. They are not home inspectors, but man, they act like it. So page 2 of and that's why VA financing tends to take longer. Page 2 looks a lot like page 2 of the other finance contingencies, except in the amendatory clause, there is not a time frame for the appraisal, and there is not an amount for the appraisal, because the appraisal does have to hit the purchase price. It's not an option. Now, the VA funding fee. VA funding fee is 2.75% of the loan amount. It is huge because the veteran does not pay a monthly mortgage insurance premium payment, so it's all paid up front. Now, if the veteran has a certificate of eligibility because they served during time of war, they do not have to pay the funding fee. But to get a VA loan, you need 2 certificates. You need one stating that you're a veteran and you are eligible to receive a VA loan, and the other one would say that you are exempt from the funding fee. My active duty service was not during time of war, so I do not have a funding fee exemption. But there are a lot of veterans these days that served in Afghanistan and Desert Storm, and they have an exemption for the funding fee. So make sure you understand what those things are, and make sure your veteran is getting those things. They can be acquired fairly quickly these days. Back when I was using my VA, you physically had to go to the VA and request your certificate, and it took forever. But now they can be obtained fairly quickly.
For disability, veterans with a disability, they're still exempt too, correct?
Depends on how they were disabled.
Oh, okay. They would have a certificate.
People who were disabled when I was in the service don't have that exemption.
Okay.
All right. So depends on what their disability is related to and when their active duty service was. But they should know. Most veterans do know. Now, there are some veterans out there, and it's unfortunate because they don't teach financial classes when you're in the military. And there are veterans out there that think it doesn't matter what their credit score is. They're a veteran, they can get a loan on a house. No, you still have to have reasonably decent credit. You cannot have a 500 credit score or been foreclosed on a VA loan last year and get another VA loan. It's not going to happen. So if somebody calls you up and says, I want to look for a house, and you say, have you been pre-approved by a lender? And they say, I don't need to. I'm a veteran. I'm going to get a VA loan. Explain to them gently that everyone has to get pre-qualified. Okay, repairs paid by seller. There is not an option for the veteran to pay for the repairs. They will be paid for by the seller. And in what amount they will be paid depends on what you put here. Again, it's all still negotiable if the repairs exceed the amount listed. But those repairs will be paid for by the seller. I don't understand what you're trying to say, Brian.
So what I did is, so those who don't understand what a mandatory clause means, I just put in the chat what is an mandatory clause. I imagine most folks didn't even think, or you're like, I don't know what that is, and I think I should know what it is. The mandatory clause is exactly what I put in the chat. It just says you can't, the lender can't make you buy it. No one can make you buy it if it doesn't appraise. So that's not part of conventional, it's part of FHA and VA. So if someone asks you a question, what is the mandatory clause? That's what it is. 90% of agents have no idea what it is. Be smarter than 90% of the agents out there.
That's why you're on this call.
So you have it exactly in writing. I would, if I was anyone here, I would copy that down somewhere and just have it in your back pocket.
Okay, the last page talks about VA rules and regulations. This is an interesting paragraph. This paragraph changes every year. Currently, this paragraph says that the VA requires a termite letter. Right now, the only lending in the market right now that requires a termite letter is VA. FHA used to. They don't as often anymore. They can, but they don't on a regular basis. VA does require that. If the seller cannot provide a termite clearance letter, they have to get a bond on the house to get that termite clearance letter. That is just, it's a big paragraph, but that's all it says. Home warranty, if the improvements on the property are less than a year old at the time of closing, seller shall, if required by the VA, provide a home warranty at the seller's cost. Same thing as the FHA finance contingency said. Public water and sewer, we've got that in this finance document also, and the seller pays. Seller agrees to pay. There is no option for the veteran to pay. The seller pays. So we've got signatures, and that is the VA finance contingency. Any questions? Okay, we will move on to the all cash sale exhibit. This is the exhibit that you're going to use if your buyer is paying cash or if your buyer is obtaining non-institutional lending, hard money. So the top is the same as in all exhibits. You give it a letter, you give it the date that's on page 1, put in the property address. Section 1 says, all cash sale while buyer has sufficient liquid assets to purchase the property in this transaction for all cash, buyer either A, reserves the right to pay all or a portion by obtaining institutional first mortgage lending, and or reserves the right to pay all or a portion of the purchase price by obtaining non-institutional first mortgage lending. So in other words, it's not an all cash sale exhibit. If the buyer can obtain lending, they are trying to convince the listing agent and the seller that they are still going to pay for the property in some form of financing, I guess, that doesn't have any contingencies attached to it, okay? You're going to get institutional lending and you're going to have a conventional loan contingency. that your loan approval is contingent on your being able to purchase the property. What they're saying here is if they're going to get institutional or non-institutional mortgages, they are not putting that contingency in the contract. They are going to get that type of lending, but if their lending is denied, they're going to forfeit their earnest money. So in other words, when you get one of these financing or this all cash sale exhibit, make sure there's plenty of earnest money. I like to see when somebody's paying cash for a property, I want 10% earnest money. That's my rule. You're not going to be selling $500,000 houses and people are going to pay cash for them on a regular basis. So you don't need $50,000 in earnest money. Typically, these are going to be $100,000, $200,000 properties. Then you want 10 or 20 in earnest money, or as much as you can get. The flip side of this is they have an either or. So they can reserve the right to get a mortgage or not. And that's section B. Buyer shall not have the right to obtain a mortgage or financing of any nature, which means they are paying cash. Okay? The buyer also will have no right to unilaterally extend the closing date for reasons of mortgage lender delay. I don't know how aware you are of the unilateral extension. We're going to talk about that one next week, but the unilateral extension is an extension that can be invoked by either party without the other party's permission due to problems with the lender and problems with title. Problems basically beyond the realm of something a buyer or a seller can control. So when you see an all cash sale contingency, the buyer is either going to reserve the right to get some sort of mortgage or is going to pay cash for the property. Verification of funds. They are going to provide within X number of days from binding agreement their ability to either obtain one of these mortgages or pay all cash. That proof of funds is going to be provided in the form of a letter from their bank or a bank statement with their name, their address, and the balance in that statement to show you and your seller, if you're the listing agent, that they have the ability to pay cash for the property. If they want to wait, they want 5 days for due diligence and they're not going to provide proof of funds for 5 days. I push back really hard on that. I want proof of funds up front. You're not going to pull my property off the market for 5 days and make me wait to have you terminate, and I don't even know if you've ever even had the ability to purchase it. That's something that a wholesaler tries to pull. Now I got a couple of questions. What is the advantage and to whom for an all cash sale exhibit? Is that what you're asking, Tina? The advantage is if you're paying cash, most sellers in a multiple offer situation will accept a cash offer over a financed offer in a minute, because that's more likely to get to the closing table. They might terminate during due diligence, but their due diligence periods are typically much shorter. Even if they are getting some sort of mortgage, they're not making the purchase or their closing of the purchase contingent on a mortgage.
Okay.
Okay.
Mhm.
And back to Naruna's question, she asked if commission works different for VA loans. No, commission is commission. It doesn't matter what kind of loan or financing a buyer's getting. So, verification of funds. Again, you want to get that as early as you can if they're paying cash. Authorization and security. Buyer does hereby authorize seller and listing broker to communicate with any persons in this transaction regarding their funds and their ability to purchase, but without risk of identity theft, okay? They're providing bank statements sometimes. You want to make sure that if you've got the buyer, that any social security numbers and any account numbers, any routing numbers are all sufficiently blacked out to the point you can't hold that piece of paper up to a light and read the numbers through it. Seller's right to terminate in the event the buyer fails to provide the required documentation. Seller will notify buyer of the default, and then they still have 3 days to deliver their proof of funds. So if they're late with the proof of funds, this is the seller's right to make a second request for it. The buyer has 3 more days, and if they don't provide that proof of funds, the buyer can terminate. Or the seller can terminate, sorry. Appraisal contingency. An all-cash buyer can get an appraisal, and they do. It is their right. They can select here that they shall or shall not. Usually if a buyer is paying cash, they're an investor, they know what they're getting, they're typically not worried about an appraisal. But sometimes I've seen these come across where they have requested the right to get an appraisal. Selection of the appraiser will be by the buyer, the seller, or other. Other is in the event that they're getting some sort of institutional or other hard money loan, that entity may request an appraisal, and they need to disclose who that entity might be. If the property does not appraise, the buyer does have the right to request that the property price be reduced, and they can put in the number of days here. Typically, if it doesn't appraise, they just walk, but again, typically they don't get appraisals. Buyer not obligated to seek a price reduction states just that if the property doesn't appraise, the buyer doesn't have to ask for a price reduction, but they can. And then we have initials on this one, no signatures. So that's what an all-cash sale exhibit looks like. Do we have any questions about that? Why it would be used, how it would be used, when it would be used? Okie dokie. Some other typical exhibits, just real quickly. We're going to go into the DeKalb County plumbing disclosure. If you don't live in DeKalb County, you're going to be selling property in DeKalb County, just because that's where our office is. This directly relates to properties in unincorporated DeKalb County. Not the city of Decatur, not the city of Clarkston, not the city of Stone Mountain. This exhibit came into existence probably 12 or 13 years ago. It was something that was going to go statewide. DeKalb County invoked it because they had water restrictions. Nobody else ever picked up on this, and DeKalb County has never dropped it. So DeKalb County is the only county, if you are selling a house that is in unincorporated DeKalb, this document has to be included in your contract. Basically, it states that the buyer can turn on water to the property for 30 days. And if within that first 30 days or at the time of making application for water service, they do not provide a low flow plumbing certificate signed by a plumber or a home inspector, their water will be abruptly disconnected after 30 days. I've seen it. People thought this was just a suggestion. It's not. Low flow plumbing fixtures are fixtures that were built and installed after 1993. Home inspector knows how to check for this. I can show you how to check for it. All you do is pull the lid off the toilet tank, and there's a date stamped on the lid. Turn it over. Faucets, if you've got an old faucet, you can actually make it low flow by just screwing off the aerator at the end of the faucet and putting on one that will restrict water flow. The only fixture that is exempt from this is tub faucets, because they figure if you're going to turn on the tub faucet, you're going to fill the tub, doesn't matter how fast the water comes out. So water has to come out in a restricted fashion for shower heads, the sink faucets, and the toilets. Okay, this isn't something that requires anybody to do any work. It doesn't say the seller has to upgrade the toilets and the faucets. It doesn't say the buyer has to do it. It just says that in order to get water turned on beyond 30 days after move-in, you have to provide a plumbing certificate. There are some agents out there that truly believe if you include this with your offer that it obligates the seller to install updated fixtures, and it does not. Any questions? I said that. So the lead-based paint exhibit. If your property was built before 1978, the seller should have filled out one of these, and it would be provided to you as an attachment to the listing, like the other attachments were there in the listing earlier, or it could be provided to you, they could send it in email. The seller does need to fill this out first. Top portion is the same as everything else. You give it a letter, a date, and an address. And it says, the seller is talking about the presence of lead-based paint and or lead-based paint hazards. The seller knows that there's lead-based paint or lead-based paint hazards, or they have no knowledge. Records and reports. The seller has records and reports or has no records and reports. Just because a house was built before 1978 doesn't mean the seller has done testing and is 100% aware of lead-based paint hazards. Getting rid of lead-based paint hazards, the easiest way is just to paint over it. Since 1978, any house that was built before that probably has been painted 6 or 7 times. That lead-based paint is buried underneath layers and layers of paint. So unless a seller has specific knowledge, they are going to check that they have no knowledge and no records, and they're going to initial up here. Your buyer has the option to take 10 days to have a risk assessment done. In other words, they're going to chip paint off the house and have it sent off to a lab to have it tested, or they're going to waive their opportunity to do a risk assessment. I strongly suggest you tell your buyer that they need to check this box and evaluate whether or not they want to do the actual testing. But you're also going to provide them with the pamphlet, Protect Your Family from Lead in Your Home. Your buyer is going to initial here. The broker's acknowledgement section is where people mess up a lot. Broker's acknowledgement. Broker has informed the seller of seller's obligation under U.S. Code 4852D and is aware of his or her responsibility to ensure compliance. Broker has informed seller. Which broker do you think initials here? The listing broker or the selling broker? It's the listing broker, because that's the broker that has informed the seller of their obligation by providing them the lead-based paint pamphlet. So the seller will have signed here, their agent will have signed here, they may or may not date it, but you want the seller to fill this out first. Any questions?
Nope.
Okie dokie. Now we're going to get into some fun stuff. We have the backup agreement contingency, the sale or lease of buyer's property contingency, and the temporary occupancy of seller after closing contingency. Which one, does anybody care which one we go through first?
Temporary occupancy.
Okay, he has spoken. Okay, this is the exhibit. If the seller is going to stay in the house after closing. So on page 1 of the purchase and sale agreement, if your buyer is not getting possession at closing, and the seller is staying in the house even for 1 day. This exhibit needs to be attached to your offer. It gets an exhibit letter, a date, and an address. It's not to be used if occupancy is for more than 60 days, so it does have a 60-day limit. I hope that the seller is not going to stay there more than 60 days, but this does have a 60-day limit. Had a request to make this bigger. Does that help?
Yep.
Okay. Seller shall have the right to continue to occupy the property for X number of days after the closing is consummated at X o'clock AM or PM. I strongly suggest you make this 5 o'clock PM, 5 or 6 o'clock PM, or noon. That works too. Make sure you know the difference when noon is PM, midnight is AM. But you put in here the number of days that they're going to occupy the property. That is going to be the term of the occupancy period. At the time of closing, seller shall provide buyer with 1 set of keys. We allowed occupancy for a week once on one of my contracts, and the seller didn't bring keys to closing. Oh, sorry, we forgot. But we'll meet you on Wednesday at noon at the property and pass off keys. Come Wednesday at noon, they were nowhere to be found. Couldn't find their agent, couldn't find the seller, couldn't get into the house. No lockbox, nothing, everything's gone. I had to call a locksmith and pay for a locksmith to break into the house and rekey all the locks. Okay, I was representing the buyer. I took that on as my responsibility. I could have made the buyer pay for it, but I should have made sure that I got a set of keys. Even if the seller didn't bring keys to the table, I should have gotten a set of keys the next day or that afternoon, and I didn't. Make sure you get that set of keys. That buyer owns that property. They are now basically the landlord. Every landlord has a set of keys. Until time of possession, buyer shall arrange for common element access with the community association. So if there's a pool and tennis courts and the buyer wants to use those, they just talk to the association and explain, we're letting the seller stay for X number of days, but we would like to come and use the pool. So they need to get access keys and fobs and things for that. Seller agrees to maintain all utilities in seller's name and pay the bills for such as they become due. They're tenants. Tenants pay utilities typically. They're going to pay for the utilities and keep them in their name. Seller will not make any improvements or modifications to the property. That's the big one.
Right.
It's common sense, but you know, you've got a seller who in some cases might have lived in that property for 20 or 30 years. If they want to do something because they're staying for 60 days, they just might go ahead and do it. It's weird, but yeah, they just might do it. So we have to put that in there. Seller hereby expressly releases the buyer, the listing broker, the selling broker, and their affiliated licensees, being you and I, from any and all liability of any nature whatsoever, which may arise as a result of seller's acts or the acts of other people that they have come to the property, liability, etc., etc. Seller holds everyone harmless if something happens to the property while they are still in it. Okay, so they need to maintain some sort of insurance, some sort of liability insurance. If they have a party before they move out and something gets destroyed, they need to fix it. If somebody gets hurt, they need to pay for it. That is not the seller's responsibility. It is specifically understood that should the property be destroyed by fire or other occurrence, seller shall bear the risk of the loss to their personal property. So the buyer still needs to have insurance. But the buyer is not responsible for the seller's personal property if the house gets burned to the ground. Now, granted, the buyer has to build a new house. Maybe they're happy about it, maybe they're not. But they are not responsible for the seller's personal property, just like in a landlord-tenant situation. A lot of these things are similar to landlord-tenant situation. Seller shall be liable for the expense of repairing any damage to the property caused by the seller, their family members, licensees, invitees, excluding normal wear and tear. Again, if they kick a hole in the wall or do something like any seller might have happen when they're moving out of a property, they got to fix it.
Mhm.
Upon notice to seller, buyer and or buyer's representative shall have the right to enter the property. I've got a property right now. We closed February 7th. The seller has it until April 7th. 60 days free rent. It was the terms of the contract. That's what they had to do to get the house. But we've gone in a couple of times. We made an appointment. They wanted to do some measuring. They want to do some renovations. They wanted to get a feel for where they were going to put furniture. So we made an appointment. We went into the property. We did our measuring. We left. If seller does not timely vacate the property by the end of the occupancy period, they shall be deemed a tenant at sufferance and will pay X number of dollars per day for each day after the end of the temporary occupancy period. Make this painful but not ridiculous. If the buyer's mortgage is $1,000 a month, you can make this $35 a day. Or if you want to make it painful to make sure they get out, make it $50 a day. A lot of this has to do with what's the typical rent for the neighborhood, what is the buyer's mortgage. The seller does need to at least cover the mortgage, but you want to let the seller know that it's not okay to hold over. It's not okay to stay past the date that's indicated in the contract. In the event either party is forced to resort to litigation to enforce a breach of this agreement, which is typically holding over, the prevailing party shall be entitled to recover their court costs. Loser pays. In the event there's a conflict with the terms of this agreement, the terms in this exhibit shall prevail. Okay? So whatever this exhibit says goes. Even if there's a conflict with the actual purchase and sale agreement itself, this exhibit, what it says, will prevail. So if the page 1 of the purchase and sale agreement says they have until April 1st to get out of the property, but you accidentally put up here, or somebody accidentally puts up here that they only have 30 days, which means it would be March 7th. This exhibit prevails and survives the closing. This temporary occupancy agreement shall survive the closing. So when you have a buyer that has to allow the seller to stay in a property past the date of closing,
Mhm.
this is the exhibit that you want attached to the contract, and you want to make sure that your buyer understands the terms. If you're the listing agent, you want to make sure your seller understands the terms. They're getting to stay. There may be an amount that they're paying for rent that's in the purchase and sale agreement. It's not here, but there is an amount they will pay to hold over. And there is a date as to when they have to be out. They have to keep utilities on. They have to fix things. They have to insure their personal property. Any questions?
Okay, and out means all the way out. No cameras and none of that.
Correct.
Okay.
Unless they have security cameras that are transferring with the sale. But once they're out, it's the buyer's property and the buyer can take those cameras out. Okay?
What cameras are you referring to? Is that an issue?
Oh yeah. I've got,
I was hoping she was going to tell the story about, but it doesn't really apply here. But I was hoping she was going to tell the story about somebody leaving some cameras behind and actually watching
oh yeah,
in the house. But that's
Oh,
I
okay.
got a property listed right now. It's under contract, but it's listed right now. The owners are father-daughter. Father moved out of the property. They were living there together happily for about a year. Father moved out, moved somewhere else, had to come back to Atlanta. Daughter wouldn't let him back in the house. Wouldn't allow him access at all. He had to hire an attorney. 3 years later, they got a judge to force the sale of the property because they are both on the deed, joint tenants, right of survivorship. When the daughter and her husband and family moved out, they left behind security cameras. And the connection to the internet was still up. They wanted to watch people coming in and out of the property while it was listed for sale.
see.
And see what
They
comments they had on it?
Huh?
To see, I guess, what comments they had on it?
I don't know what they wanted to see. I don't know what they wanted to know. I don't care. I disabled the cameras. I pulled all the equipment. It's sitting in a box underneath my desk right now.
That's kind of like with my
I
orientation with Heather. She said, yeah, you'll discover there's so many different stories and you just can't make this stuff up.
You can't. They screamed. They knew the minute those cameras went offline. In fact, initially it's unplugged them. And I went back 2 days later and someone had plugged them back in. They're not supposed to be accessing the property per the court order. So somebody went in there, plugged them back in. I pulled them out completely. I took them off the wall mounts, put them in a box, emailed their attorney and said, I took the cameras out. And he says, they want them there for security. And I said, I'm responsible for the security of the property. We don't need cameras. There are sellers that have cameras in their property to spy on the buyers. You need to be careful when you are showing property. What you and your buyers say, it might be being recorded. There might be a nanny cam in there. You don't know. They do it on TV and sellers have suddenly gotten the idea that it might be a good idea for me to do that while my house is listed for sale. It's not necessarily legal, but they do on the property. So I have a question. Where do you write the amount of money that the seller is paying for the period they're staying in the house? That's in the purchase and sale agreement. So if they're going to stay over for 7 days, you're going to write a stip that's going to say, seller is going to stay in the property for 7 days at no cost to buyer or seller is going to stay in the property for 7 days and pay an amount of X number of dollars for rent at closing. They pay it at closing. And it goes on the closing settlement statement. The attorney puts it there. So if there's an amount being paid, it's in the special steps of the purchase and sale agreement. It should be somewhere in here, and it's just not. So you have to write a stip. And there is a stip pre-written for that. Any other questions? Okay, we will go to the backup agreement contingency next. Now, the backup agreement contingency is what you can use if your buyer just loves the house, it's already under contract, and the listing agent agrees to present your offer to the seller and bind it as a backup. I talked about this briefly yesterday. There are, and at other times, there are a lot of agents out there that'll say, yeah, send me a backup offer, and then you never hear from them again. Literally never hear from them again. When you send an agent an offer with a backup agreement contingency, they can bind that offer because it is not an offer to purchase, it's a backup offer, and the verbiage is in here. But it does state that if the primary buyer does drop out for any reason, whether they terminate during due diligence, whether their financing is denied, whatever, that happens during the term that is defined in this agreement, your buyer is automatically the primary buyer of the property. So that's why it's important to send this document and get that contract signed and bound. Typically, if I have a listing where I've gotten multiple offers and my seller selects and binds one, I will counter the second offer, the second best offer, with a backup agreement contingency. So I will, from the seller's perspective, offer the buyer a backup position. Obligates them to nothing. They can terminate this backup agreement contingency anytime they want. But it does give them first right of refusal if the primary buyer terminates. And what that says is, again, this is put an exhibit letter, an offer date, and the property address. Then it says buyer and seller acknowledge that this agreement is a backup or secondary agreement to the primary. The binding agreement date of the primary agreement is, and you get that from the listing agent, for the purchase and the sale of a property between the seller and you put the name of the buyer. It's not top secret. That's why I tend to do this as a counteroffer myself. So you put the binding agreement date of the contract, and you put the name of the buyer. Your buyer has no right to purchase the property unless the primary agreement is terminated. Okay, this is a backup offer. Make sure your buyer understands that. There are some buyers that would think, oh yeah, I'm buying the property, I'm going to order my home inspection. Make sure they understand the terms of the backup. Upon the closing of the sale of the primary agreement, this agreement shall automatically terminate. Buyer shall be entitled to a refund of their earnest money. Buyer agrees that any amendments to the primary agreement shall not alter this agreement in any way, shape, or form. Amendments to the primary agreement are amendments to the primary agreement. Buyer acknowledges that buyer shall have no right to examine or be advised of the terms of the primary agreement. Sometimes the terms that you submit for your backup need to match those of the primary agreement. Sometimes they don't. The listing agent will tell you if they do, but you have no right to look at that primary purchase and sale agreement. That listing agent just may come back and say, no, 100,000 is not enough. You have to offer 105 and no closing costs if you want to be a backup. And you just have to take them for their word that those are the terms that are probably in the other offer. I had a seller or a buyer that got really crazy on me. Well, they called for best and final. How do I know they have other offers? Why do I have to match the primary offer? I said, then don't do it. Just don't do it. Let it go. I need to look at that contract. No, you can't. I'm sorry. Paragraph 5, in the event the primary agreement is terminated, seller shall deliver notice of the same to your buyer. This agreement shall become primary and is no longer subject to this contingency exhibit. So they're going to deliver, there's a GAR form called notice that they should send to you, the listing agent should send to you, stating that the primary buyer has terminated and you are now the primary buyer. Buyer and seller shall close on this agreement in accordance with its terms and conditions, provided that all parties agree that the time limits, except delivery and deposit of earnest money, shall commence on the date that notice is given. So you've got 21 days for financing. That would start the date that notice is given that you are now primary. It didn't start when the offer was bound, as typical. It starts when the offer becomes primary. Does that make sense? Closing date shall be the date listed in the agreement, unless because of the change in the binding agreement date and time periods to conduct due diligence and fulfill other contingencies go beyond the closing date. Therefore, the new closing date shall be 7 days from the last date the buyer has to fulfill a contingency. What that says is you've picked a closing date of March 30th. Your offer becomes primary March 15th. You have 21 days for financing. This means that your closing date will be changed to 7 days after your finance contingency expires. So 28 days from date of notice, unless you do an amendment to change the date in some other way. So when you're submitting a backup offer, most offers will terminate during due diligence. You can ask the agent, how many days does the primary buyer have for due diligence? Well, they have 10 days. Okay, so you push your closing date out 10 days from that date. Your contingencies for due diligence, finance, and appraisal don't begin until the other offer is terminated, if it's terminated. But you know you're good on your closing date and you don't have to do any modifications. Got it?
Yeah, and your earnest money, that's activated when it pops up.
Earnest money is delivered up front when the contract says. So if your backup contract is bound on March 1st, earnest money is due within 3 days, it's still due. And it's still going to be deposited and held. But your buyer will get it back if the other contract closes. But earnest money is the only thing that's exempt from that change in the dates. Okay.
Okay.
Last statement. If this agreement has not become primary buy, this is key. If your buyer wants to hang in there through due diligence, you put the end of the due diligence date. So it's March 1st, they have 10 days due diligence, you put March 11th. If this agreement does not become primary by March 11th, it automatically terminates and the buyer gets their earnest money back. Most buyers don't want to hang around for 30 days unless they really, really, really like the property and were really, really, really stupid in making their offer and lost out on multiple offers. Or if they came into the market after this property went under contract and they fell in love with the pictures and you got to see it and yada, yada. So it's not something you're going to use often, and it's a very short exhibit. It doesn't have a lot of stuff in it like the temporary occupancy. But just understand that the listing agent has to fill in this information up here and make sure your buyer understands the terms in paragraph 5. Okay? I like backup offers as a listing agent because then I let the primary buyer's agent know we have a backup offer. And that implies if your buyer doesn't play nice during due diligence and makes all kinds of demands, we're going to kick your butt to the curb and we're going to go with the backup offer. Okay?
Yeah.
And just know as the backup offer, a similar thing applies. Know that if that primary buyer was kicked to the curb during due diligence, that doesn't give your buyer carte blanche to ask for everything in the inspection report. Okay? They need to play just as nice because that agent could accept another backup offer behind this one.
Okay. Leverage.
It's a high demand property. They could. So, all right.
All right.
Okay. Last but not least, sale or lease of buyer's property contingency. Sellers hate this. They hate taking their property off the market, knowing the buyer can't buy their house unless they sell the house that they're in. And that's what this says. It says, I, as the buyer, have a house I have to sell. If I don't sell my house, my loan won't get approved and I can't buy your house. But I still want you to take your house off the market because I really want to buy it and I don't want anybody else to get it. And I want you to sit back and wait for me to sell mine. Makes no sense for a seller, typically, unless their property's been on the market like 60 days, 90 days. They haven't gotten any other offers. Usually then they'll take one of these. But these are the terms of the sale or lease of buyer's property contingency. You have an exhibit letter, a date, a property address. Buyer warrants that their property located at address with a city, state, and zip has taken or is taking the following actions to sell or lease that property. They better be able to fill in here that the property is on the market. I have gotten these where the buyer said, well, we're going to list our property in the next 30 days. What? No, I am not taking my listing off the market or advising my seller to go under contract with you while we sit here for 30 days waiting for you to put your house on the market. It needs to be on the market now. This agreement is contingent upon the occurrence of the following on or before a specific date. And that is the buyer closing on the sale of their property or the buyer entering into a lease on their current property. So they're going to put a date here. They're going to say, within the next 30 days, I'm either going to close on the sale of my house or I'm going to enter into a lease to lease my home, which is the only requirement I have to get my new mortgage. That means that the closing date on this contract is probably 60 days out. So be careful how you fill this in. This used to say getting a contract on the house. It now actually says closing. You actually have to close. Running simultaneous closings is hard. The property needs to be already under contract, not just listed to sell. And then that's a little bit more of a secure situation. If the property that you have or your buyer has is under contract, you've gotten through due diligence, you're just waiting on the appraisal and the buyer's loan approval to close, that's the ideal situation for using this exhibit, because you know you're probably 3 weeks out from closing. You can detail up here the following actions. The property is under contract and due diligence has been completed. So you can confidently check that you're going to close on the sale of that property in order to buy this one. You need the equity from it. That's fine. I usually am pretty good with that. So again, it's only contingent on the sale, the close of the sale, or the entering of a lease. And their pre-approval letter better say they only need to lease the property versus sell it to get loan approval. Now here is the kick-out provision. Yes. The kick-out provision, you've seen properties listed in the multiple listing service with CKO, contingent with a kick-out. This is the type of contingency they're talking about. So the buyer and seller can either agree that the seller will have the right to continue to offer the property for sale because this agreement is subject to a kick-out. And that's when a property gets listed with a status of CKO. All right. Or it is not subject to a kick-out. So the first option here is not subject to a kick-out. The second option is subject to a kick-out. In the event the seller receives an acceptable offer to purchase the property, seller shall give the buyer notice of same. Buyer shall then have X number of hours after receipt of that notice to deposit additional earnest money in the amount of X and to deliver seller an amendment signed by the buyer in which buyer agrees to remove the following provisions of the current exhibit or current agreement. So this gets a little convoluted at this point. So if there is a kickout and the seller gets an offer on their property, say they've put in here that the buyer has 24 hours to either deposit an additional $5,000 in earnest money and remove all or some of the contingencies in the contract and move on to closing, or terminate. So when you see the status of a property that's CKO, you can still show it and you can still make an offer and you can kick out the current buyer. Buyers will ask all the time, can I kick out the buyer that's there? Not in a typical contract, not unless there's a kick out provision. So these are buyers that have gone through this process or know somebody who's gone through this process. Most buyers in doing this type of contingency will try to get the seller to not make it subject to a kickout. A good listing agent will require that it's subject to a kickout, knowing that there's not a lot of buyers that are going to look at a property that is under contract, whether it has a kickout or not. And then either requiring the buyer who has this contingency to remove due diligence, finance, and appraisal from the contract, and all earnest money is at stake if they don't close. And of course, they don't get to ask for any repairs, or they can remove just certain contingencies.
Okay. So the extra earnest money is me bribing my way from getting kicked out?
Yeah, I've got a contract right now that's not going to close on time and the buyer wants an extension. Okay, I'll give you an extension. I want more earnest money.
Right. So I got to pay you a little more money to keep from getting kicked out, and say I'm forfeiting all the other contingencies that I suggested. I mean, all the other, to keep from getting
Right.
kicked out. Right.
In this situation, yes. If in this situation, if they terminated the offer, they would get their earnest money back. Or again, they can offer more earnest money, showing that they're truly earnest in purchasing the property, truly interested,
Right. Right.
and they can agree to remove all contingencies or some contingencies. This is all agreed to up front before the contract is bound.
Now,
So if time of kickout happens, go ahead.
does the backup thing kind of work? Like, I mean, can I add more earnest to move? That was the thing with the backup that we talked about last time. What can you do to move up the ladder? But all the leverage is with the listing side of it, the seller, I guess.
As a backup, you don't have any leverage.
Exactly, none at all.
No. The seller, you agree to terms with the seller and you got to wait for the primary buyer to terminate. I've had sellers play hardball when we have backup offers and refuse to do any repairs. The buyer that we're refusing to do repairs for knows we have a backup offer. The backup offer, I will have notified that agent saying, seller's refusing to do repairs, trying to kick this current buyer out, but understand they're not going to do repairs for you either. And be upfront about what is wrong and not wrong with the house. But in this situation, they probably haven't even gotten there yet because due diligence probably hasn't started. Due diligence is usually a long time period when you're doing this type of contingency on the sale of a buyer's property, unless that property is already under contract. So again, it's what concessions does the seller want? What concessions is the buyer willing to accept? If the buyer really wants that house and the seller wants a kick out, they'll agree to it. The seller holds all the cards.
Right.
In both of these situations. But just know that those options are out there. When it comes time that you need to use this, we'll definitely sit down and go over this in more detail. just to make sure that you fully understand it. But just know that these options are there. Now, this last paragraph says, in the event buyer does not deliver within the time period stated above, the additional earnest money or assigned amendment, their right to purchase the property is terminated. Okay? It's a simple paragraph. You know, it says you either comply with what's in this or the contract's terminated. You still have to send out a termination and release document that they have to sign. They can refuse to sign it, but they'll lose because of what this paragraph says. Okay?
And the buyer gets their earnest money back,
Yes.
right? Okay.
Yep. And we'll talk more about TNRs next week. I wanted to save that for next week. But we've covered a lot of information today. I'm sure your head is full. But again, the object of this is just to know these things are out there for you to use. And when it comes time to use them, say, hey, I know we went over this, but can you go over it with me again? Not a problem. You need to be able to explain this to your buyers. And I tell my buyers all the time, we're going to go over these documents multiple times. You're going to have multiple questions. My buyer who has the seller who stand for 60 days has hit me up 3 or 4 times in the last 60 days saying, okay, what did that agreement say again? What's going to happen if they don't move out? And I tell them the same thing every time, but they have the right to ask, and I need to explain it. So you have the right to ask. Agents don't use these forms every day.
Can you please remind me where we go, where that back office is, where we see these, where we get to these documents?
In our docs.
Oh, in our docs. Okay, sorry. I had a
All of
call
these are
earlier
VAR
with
forms.
Brian, and we were looking at some other documents. I think I'm getting them all confused on where to go.
All of these contract forms written by the Georgia Association of Realtors are in our docs. You can go into our docs and you can actually print out a list of all of the documents that are available.
Okay.
And, you know, F601, sale or lease of buyer's property contingency exhibit. Okay.
Great. Thank you.
So there's 100 forms out there. There's a lot to understand.
Literally.
You're only literally, you're going to only use a dozen, maybe 2 dozen of these forms on a regular basis. And the rest of them, just know that they're there, that they're options. If a buyer or seller asks you, can we do this? Say, let me check. I'll get back to you in a couple of hours. Call me or Brian or comb through the form. See if there's a form that covers it. When you need to extend a closing date, and again, we'll talk about amendments next week, but there's an amendment to change closing and possession. There is a specific form just for that. You don't have to make up any verbiage. All you do is fill in the new closing date and get everybody to sign it. But in other cases, there is not a pre-written amendment. So you have to become an attorney and write some verbiage and just be very careful with what you write. But again, there's only a couple dozen forms you're going to use on a regular basis out of over 100, I'm sure, that are there.
I think my personal fear with it and being new is when something does go on, if it's, say, a hot property and things are moving really fast, I would hate for my pace to cause my client to lose out on something.
Well,
like,
you know, when you write your first couple of offers, you're going to call me and say, Eileen, my buyers found a house, they want to make an offer, and you're going to tell me the situation. You're going to tell me, I've already talked to the listing agent, they have 3 offers. I have until 5 o'clock today to get this to them. If that's the situation and I don't feel like I have time to walk you through it, I can write an offer in 20 minutes. I will just write it up for you and we'll go over it later. If we have to, but most of the time we're not going to be in that kind of crunch situation. But if you are in a crunch situation, just know that I can get into your login and I can type up that offer and I can get it out in e-sign and we can turn it around quickly.
Okay, thank you. In the comment section, Eileen, can you put in your email and your phone number?
Yes. Yeah. I'm sorry. You're so new. We didn't even get any of that to you.
I am super new. Right now, I'm doing, the analogy that they give. I'm drinking from the fire hose.
Yeah. No, I understand. And it's a bad time to be drinking from a fire hose.
It is.
Because you can't go to the board and sign up right now, and you
I
can't
know.
go to get a key right now, and you can't do all these things. It's Tina called yesterday and said, I can't knock on doors. How do I find clients? And it's a logical question, but you want to be on Brian's call on Thursday to talk about that, because that's what he's going to talk about. But there's my email and my phone number, my cell phone.
Oh,
Is
great.
there
Thank you so
a
much.
list of documents, let's say from each side, whether you're the listing agent or the buyer's agent, is there like a list of those documents that pretty much are true to each one, to each of those?
You're
Like,
talking about a set
Like the
of
forms.
documents.
Yeah, what documents are pretty uniform to the sale or to the, to the listing that when I was in the FMLS class, the one thing I remember, but I couldn't do, they made a packet, like that you made a personal packet of forms and that
You
were able
can,
to just pull them in each time.
oh shoot, hold on. You can do that yourself. But I do have a document that I can send to you. And I probably haven't given it to you, Tina. I've given it to just about everybody else, but email me and ask for this, but I'll show you. Hang on. I have what I call a buyer contract checklist, and I have one for sellers too. And what that is, it's a checklist of forms that you might need in making an offer or pulling together a listing. So you can see here the buyer contract checklist. I've got a buyer with this address. They want to make an offer on this property address. Here's my Georgia MLS number, my FMLS number. This goes in tandem with your offer worksheet that I gave you yesterday. The possible offer documents that I might need are obviously a purchase and sale agreement. I'm going to find out if there's a seller's disclosure, a community association disclosure, and there's the document number. It's an F322, okay? DeKalb County plumbing disclosure, lead-based paint exhibit, legal description, finance contingency. And F401 is going to be the conventional, but there are others. There are others. You're also probably going to need an instructions to closing attorney. You're going to need your buyer's pre-qualification letter, a copy of the earnest money check. You might need a condo resale purchase and sale exhibit. You might need a personal property sale agreement. You might need closing attorney acting as holder of earnest money, sale or lease of buyer's property, backup agreement contingency. All of those documents that we went over today are the ones that you might need. But you use this worksheet and you say, in writing your purchase and sale agreement and reviewing the exhibits that are on page 7, you say, well, I'm going to make my legal description exhibit A. So you type in here A. I'm going to make my lead-based paint exhibit exhibit B. So you've got this as you're constructing your offer packet. You've got all this noted here, and you've had a chance to sit down and go, checkbox, this is what I need, this is what I need, and I'm going to make this exhibit A, B, C, D, E, okay? Later on, if you have to amend the contract in any way, these are the standard group of amendments that you're going to need to use. So this is something you can put in the folder that you're going to have for this property and this client. Buyer representation. You either need a buyer brokerage agreement or a customer acknowledge. That's F110, not FF110 or F116. You need the Keller Williams ABA. These are the pamphlets. These are other pamphlets you might need. Everything is right here for you. So you can create those packets of documents if you want. But that's what, this is kind of a cheat sheet of what you're going to use 99% of the time. 99% of the time. Got one for sellers, I've got one for tenants. All you have to do is email me and tell me what you want. Sorry. And I'll send these checklists to you, just like you had the buyer information worksheet yesterday. Okay. And you can also go into the GAR forms in RDocs. And you can print out the list. And having this list handy is not a bad thing. Let me get logged in here. So we go up here to select, and we go to Forms Manager. GAR Forms Index. You can download that document. And this is all the GAR forms in alphabetical order and their document number. This is a 5-page document. Print this out, look through it. There's a lot of stuff in here you'll never use. In 16 years, half these documents I've never used. Look at this. School district verification contingency. There's all kinds of stuff in here. But that is, can you see it?
No.
No. Okay. Let me make sure I'm sharing this. Okay.
There it is.
Try that. Okay. 5 pages of forms. Okay. There's a hunting rights contingency. It's a special step. Hunting rights special step. The SS212, that's a special step. Because there's also a list of special steps that you can print out. So go into RDocs and print these and take a look. Again, there's a lot of stuff here you're never going to use, but there is some stuff that you might have an occasion to use.
Okay.
So again, send me an email. I can send you this. I can send you the list of steps. I can send me an email and say, send me everything. And I will download a lot of stuff to you. Or if there's specific things you want, tell me to send those to you.
Thank you.
Now we got a few minutes left. Do you want me to pop in and out of GSCCCA, or you want me to save that for another time? What was that?
Think about it.
All right. GSCCCA is where you go to pull legal descriptions. So the URL, the website address is gsccca.org. We talked about that yesterday. Sent that out to all of you. It works now in Chrome. For a while it didn't work in Chrome, but now it works just fine in Chrome. It's taken a while to load. Okay. This is access to deed records. You have access to other things, but our access is pretty much limited to things that have to do with real estate. The login for this website is a shared login. There are over 250 agents in our office that use the same login. Understand that if you log in and all of a sudden you've been kicked out, it's because another agent is trying to get into the system. So my method and Brian's method for getting in and out fairly quickly without a lot of disruption, you're actually, all you're going to ever do is you're going to go to search, and you can set all this up before you log in. You're going to go to real estate index. You're going to go to book and page search. So you're going to have gone, once you've got your listing, you're going to pull the book and page out of the listing or the tax records for that property. Based on that, you're going to select your county and you're going to select the deed, book, and page. You can put all of this in before you even log in. Now, this is the last property I looked up, so I'm just going to leave it here. It's always going to come up. It's going to remember you and the last thing you looked up, and you just need to change this. When you hit search, it's going to ask you for your login. I've got my system remembering the login, so I log in. And I hit view image. And as soon as this pops up, okay, can you see it?
Mm-hmm.
This is the warranty deed for the property that we were making an offer on. And here is the long legal. It's always going to be highlighted like this.
And
Or
is this,
it might,
oh, I'm sorry, go ahead.
this is the legal description of the property.
Right, but earlier when you put in the book and the page, is that assuming that you've already seen it from somewhere else that you're able to put those numbers in?
You can, yeah, you can pull that book and page from the listing itself, or you can click on the link in the listing that where the tax ID is, and it will take you to the property tax records and tell you where the book, what the book and page is. I'll help you find that later on.
Okay.
Now, sometimes you'll have a deed. Oh, that's a security deed. We don't want that. Security deeds are really, really long. Sometimes you'll have a deed that has the legal description as attached as Exhibit A, and that deed will say, see attached Exhibit A. So I'm not finding one right now. But say this was our warranty deed. Pretend this is our warranty deed and this is Exhibit A. If I want to print out both of them, I can go to the warranty deed and I hit this little printer icon button. I'll tell it to print 2 pages and it will print this page and the next page.
Okay.
Or I can tell it to print 1 page and it'll print 1 page. And I can print that page to a PDF, or I can print it to my printer, print a hard copy. So if you don't know how to print to a PDF, you have a choice of printers in your destination print window. Usually, click Save as PDF. You save it as a file on your hard drive, and then you can insert that into your contract or print it later whenever you have time. But that's how you, real quick version of how you get into GSCCCA. When you have to do it for real, then we'll do this a little slower. But that's a lot of information for one day. Like I said, if anybody has any questions about anything, wants me to send you documents, send me an email, tell me what you want. I'll send it back to you. When you have to write an offer, call me. If you have any questions, you can text me. If you want to talk on the phone, text me. Say, do you have a few minutes to chat? I'll let you know if I can talk now or if it needs to be in 15 or 20 minutes or later in the afternoon, you know. Try to keep administrative type questions and calls from like 9 to 6, Monday through Friday. You're writing offers. If you got to write an offer one evening at 8 o'clock, you got multiple offers, you don't have a choice. We have to work on it at 8 o'clock at night. But for the most part, real estate doesn't happen at 8 o'clock at night. But it does happen on the weekends. And just know you can call me. If I'm busy, I'll let you know. If I can't get to you, you can. I'll tell you to call Brian, or I'll tell you when I will be available. If that doesn't work for you, call Brian. So that's why there's 2 of us. So hopefully one of us is always available. But next week, we're going to talk about counter offers, terminating your offer, amending an offer, and then the documents you need for buyer representation. So I did pretty good keeping all that to 2 hours.
You did great. Thank you so much, Eileen.
Yeah, I like
Very,
it.
very helpful.
Yeah.
Any more questions? Otherwise, I will talk to you guys next week or as needed.
All right.
Okay.
Thanks, Eileen.
Thank
You're
you.
welcome.